thank you to Dennis Galligan for having invited me to give this lecture about the Putney Debates 2021. So before to start my presentation, I want to do a quotation of a sentence from a book edited by Benz and Broszek in 2013. The book title is Federal Dynamics, because this could be somehow my conclusion after my lecture. So in principle, an economic crisis can have long-lasting centralizing effects on federal structures, as the Great Depression of the 1930s demonstrated. The struggle for fiscal authority is certainly a major battlefield in federations, as discretion about revenues and expenditures ultimately determines the capacity or room of maneuver of all territorial actors. So my task today here is to deal with the constitutional structure of Italy while dealing with the unity about a regional system. So I will start with my presentation right now. I will start quoting from the outline of the seminar, who has been written by Dennis Galligan himself. The union is difficult when regional identity has a long history, often associated with independence and ethnicity, language and religion. The United Kingdom is an old union of four proud, distinct and very different parts and peoples. And why do I start with a quotation which belongs to the United Kingdom system? Because I want to just put on the floor the main difference between the UK system and the Italian system. We do not have this kind of question, an identity or national question at stake. So I will start on the Italian case with the task to deal with the constitutional structure of Italy, trying to show how unity is achieved in its specific model of unity. I will move from the assumption that if we could say that Italy still has, after 160 years from its unification, a north-south divide, which is still at stake, I think it could be difficult to speak of a regional as a national or identity or ethnicity or independence. These are not, I mean, regional related issues by our sides. Besides the cultural and political studies on federalist thought, already present during the unification process, I mean during the 1860s, the Italian kingdom, born in 1861 and built around the former Kingdom of Sardinia and Piedmont, there was a very centralistic state. So a real regional institutional system will born just in the aftermath of the World War II with the Republican Constitution of 1948, Republican Constitution which is still in force. So in this seminar, we'll try to deal with some of the arising questions put in the outline, the regional composition of the country, the matters to be resolved to achieve national unity, the form of unity adopted, its character and features, and then an assessment of how successful the form of unity has been. You can see in the first picture here, in the first, I put just some of the contents I will try to deal with. So a short constitutional history of Italian regionalism and unity versus the so-called regional autonomy, so to say the state-regions relations alongside the system of government, the new form of government after the 1999 constitutional reform, regional distribution, legislative redistribution of powers between regions and states, intergovernmental relationships. And so we will deal with this state regions conference, which has been created by a state piece of legislation and is not in the constitution. And then the constitutional constraints and limits dealing with regional powers. We will see how strong the role of the Italian Constitutional Court is in its constitutional adjudication. And then the financial issue after the introduction of the balanced budget rule in a constitutional amendment of 2012, because Italy is dealing with many problems within the European Monetary Union. to conclude on the lack of a supremacy clause and the achievement of unity as a question at stake. So a short constitutional history of this picture shows how Italia was divided, I would say, between 1814, 1815, after the Vienna Congress, and 1848, the first independent revolutions. Unity, so the Italian unification was achieved only in the 1860s, and the Italian kingdom was a very unitary and centralized state, very different from how it appears in this picture here. This is also due to the circumstance that the unification had not emerged as a result of a popular revolution. It was an achievement of the Kingdom of Piedmont-Sardinia, acted from the top by King Vittorio Emanuele II, who's been the first king of Italy and the last king of Piedmont-Sardinia. Now that we made Italy, we must think of making the Italians. This is a very famous sentence pronounced by Massimo d'Azeglio, a statesman, historian, and politician. And with these words, he was able to give the most truthful and complicated definition of the Italian nation-building question in the aftermath of the state-building process, to put at stake the problematic lack of sense of belonging and of Italian identity among the people of different parts of the territory unified by force through the independence war. But we cannot deal with this huge historical, political, and social question now. So after World War II, on June the 2nd, 1946, the Italian people were called to vote on a referendum to choose between a republican and a monarchical state. And that is why we still celebrate every June the 2nd as the Festa della Repubblica. We celebrate the anniversary of the Italian Republic. On the same date, June the 2nd, 1946, also was elected a constitutional assembly to give to the newborn republic a new constitution, which then became the Italian Constitution of 1948, which is still in force. Although, as I already said, the regional federal question had been already debated at the time of the Italian unification during the 1860s, it was only with the 1948 Constitution that our regional form of state could eventually emerge. But we have also to recognize that the territorial regional borders were taken, as you can see in this picture, only partially along the borders of some of the states preceding the unification. More frequently, these were areas just relevant for statistical studies. So the Italian Republic can be described as a unitary state with a deep territorial decentralization. In his Article 5, one of the fundamental principles of the Italian Constitution, it stated that the Republic is one and indivisible. It recognizes and promotes local autonomies and implements the fullest measure of administrative decentralizations in those services which depend on the state. So a unitary state recognizing autonomies and decentralization as a fundamental principles. So in a unitary state with a pluralistic institutional system of regional and local autonomies, also more than 8,000 of municipalities, 8,000. What I think could be really of interest is that some of the Italian regions were formed before the Italian Constitution entry into force. In 1944, even before the end of the war, the just liberated Sicily and Sardinia were already provided with temporary institutions. And the quasi-constitutional acts, the new statute of Sicily was then approved in 1946, 2 years before the entry into force of the Italian Constitution. It was approved by a statutory decree of the provisional government. I will talk often about these statutes dealing with the regional charters, I would say regional quasi-constitutional documents, to see the documents, the pieces of legislation where the institutional architecture and the fundamental principles of each region are set down. So I will use the word statute in this sense, speaking about the regional charters. And the same occurred in 1945 with the Valle d'Aosta region, transformed into an autonomous district. Again, in 1946, due to an agreement between Italian and Austrian governments, the so-called De Gasperi-Gruber understanding, by the name of the two premier of Austrian, Italian and Austrian governments, special conditions of autonomy were granted to the German-speaking communities living in the province of Bolzano. You see the Trentino Alto Adige in the far north of Italy there. It's now divided in two special provinces, Trento and Bolzano, and this is due to this agreement with the Austrian government after the Second World War. With the exception of the Statute of Friuli Venezia Giulia region on the far east, northeast, you see, approved only in 1963 after the solution of the question of the city of the Trieste status, the regional status of Sardinia, Sicily, Valle d'Aosta and Trentino Alto Adige, which is now named Trentino Alto Adige / Sud Tirol because of the language minorities living there, German-speaking minorities, were approved. These statutes were approved by the Constitutional Assembly at the end of its works and just before its dissolution at the end of its mandate on January 1948, just after the entry into force of the Italian Constitution. Just to say, in 1947, December 27th, the Constitution was promulgated and entered into force on the 1st of January 1948. But the Constitutional Assembly prolonged its works until the end of January to, so to say, end the constituent work. And among the things the Constitutional Assembly did, among the pieces of legislation it approved, there are also these statutes of the special regions I named as constitutional laws. The Sicilian Regional Statute, already approved, as I said, by a statute law degree before the entry into force of the Constitution, was eventually converted into a constitutional law by the same Constitutional Assembly. So the three other statutes were directly approved by the Constitutional Assembly. The Sicily one was already in force due to this law decree of the transitional government, was then converted into a constitutional law by the constitutional assemblies. And these 5 regions enjoy a legal status of special autonomy guaranteed by constitutional laws. Each of their regional status being approved by constitutional law. But why? Because for all the other 15 Italian regions with regional statutes approved by a regional statute law, now adopted through a reinforced legislative process, the fundamental structure and principles of the autonomy are put in the Constitution itself, in Article 114 and followings. As already pointed out, for the 5 special regions which have a deeper autonomy, this is provided for in their own regional statutes because they've been approved by a constitutional law, as they are derogating the constitution, the general discipline of the constitution about the ordinary region. So the political reasons to grant to those regions a special legal order are connected to the peculiar needs of their territories because of their insular consistence as Sicily and Sardinia, their position of the state border, like Valle d'Aosta number 2 there, and Friuli Venezia Giulia and Trentino Alto Adige Sud Tirol, and most important, the specific rights of language minorities, French-speaking population in Valle d'Aosta, German and Latin-speaking population in Alto Adige Sud Tirol. As Article 6 of the Italian Constitution put a special provision among the general principles, the fundamental principles, to protect linguistic minorities. The Republic safeguards linguistic minorities by means of appropriate measures. And in the Trentino Alto Adige system, special autonomy is then granted to the two special provinces, Trento and Bolzano, you see, which share all the institutional and legislative powers that are usually granted to the special regions. So in Trentino Alto Adige, all the legislative powers granted to the region are, in fact, as a matter of fact, shared between the special provinces of Trento and Bolzano, which share the same special status of all the special regions. So once again, I want to emphasize that the special status of these 5 regions, 4 plus the 2 special provinces of Trento and Bolzano within the region of Trentino Alto Adige Südtirol, is in no way related to a national or identity issue. Is a question of position on the territory and protection for some of these regions of minority language speaking minorities. On the other side, regional statutes of the ordinary regions are approved by the regional legislative assembly as a statute law, although with a special legislative procedures, a reinforced procedure. It is also important to note about the history of Italian regionalism that the creation of the ordinary regions only became real in the early 70s, 1970s, when the due implementing legislation was finally enacted by the state parliament. More, the first evolving legislation was then implemented starting from 1977 with delegated statute law degrees. So let's talk about for a while the regional system of government. The regional form of government has changed within the last years because of these 1999 and 2001 constitutional reforms. The title number 5 of the second part of the Italian Constitution, which starts with Article 114, has been deeply amended in order to implement the institutional powers of the entire system of regional and local autonomies. The new Article 123 of the Italian Constitution states, among other things, that each region shall have a statute, this charter, which in compliance with the Constitution shall lay down the form of government and basic principles for the organization of the region and the conduct of its business. As a matter of fact, all regions have adopted, although not due, a presidential form of government. And it is important to draw the attention to the constitutional regulation of the regional assembly dissolution cases and procedures as stated by Article 126, especially after the Constitutional Court decision number 2 on 2004. The dissolution could happen for 2 different kinds of reasons. First of all, for political reason, when a problem comes out speaking of the political relationship between the regional assembly and the regional president. And the second type of dissolution is related to national security questions. So about the first kind of dissolution, the adoption of a no confidence motion against the president of the executive while elected by universal and direct suffrage, and the removal, permanent inability, death, or voluntary resignation of the president entail its resignation, the resignation of the whole executive, and the dissolution of the council also. And the same effects are produced by the simultaneous resignation of the majority of the council members. So after the decision of the Constitutional Court of 2004, the doctrine is, the constitutional doctrine is that the president elected directly by the people, if it's decided in the constitutional statute, and the regional assembly simul stabunt simul cadent. So the approval of a confidence motion brings also to the dissolution of the regional assembly, which reinforces a lot the powers on the president of the region. And let's talk about the second kind of dissolution, because the same article under 26 provides for emergency powers in case of risk for the constitutional and territory unity of the nation state. The regional council may be dissolved and the president of the executive may be removed with a recent decree of the president of the republic after decision of the central government in the case of acts in contrast with the constitution or heavy serious infringements of the law, and again for reasons of national security. Such decree is adopted after a consultation of the parliament. It's very important to note that the constitutional act which brings to the dissolution in case of emergency is taken by the president of the republic due to his or her position, her position as in condition of neutrality, political neutrality, and constitutional guarantee. It means that this kind of dissolution cannot be taken for political reason, just for security and safety of the national reasons, or of course heavy violation of the constitution or of the law. So the autonomic regional system on the side of legislative powers. Article 123 of the Italian Constitution, as amended in 1999, states also about the indefectible contents of the regional statutes. These acts are, as I said, the charters of the ordinary regions in accordance with within the boundaries set by the Constitution. It is important to emphasize that Italian regions play no role in the constitutional amending procedure, which is usually named as one of the most significant indicators of the federal systems instead. In the Italian Constitutional Court case law, the regional statutes are described as something very different from the constitutions of the federal member states. I mean, member states of a federal state. As a matter of fact, they share indeed a deep homogeneity, as they need to be in compliance with all the provisions of the Italian Constitution. I mean, homogeneity, despite these are autonomous acts that are taken by the regional assembly itself. Just to draw the attention on some important example of these statutes of acts of autonomy and not of sovereignty about the statutes, regional statutes. The regional system cannot use the syntagm parliament to name their regional assemblies. As the Constitutional Court has put it, parliament is the only place where the national political representation is located. As the Constitutional Court, position and role of national parliament is unique and exclusive, the Constitution banned the regional legislatures from taking possession and use for them the word parliament. This has been decided in Constitutional Decision 2002, number 106. How much this statement has to do with the use of legal concepts like people and sovereignty is, I think, self-evident, as well as this position makes it clear that no question of nation or nationality is in any way connected with the constitutional dimension of regional autonomy. As a second example, the Italian Constitutional Court also coped with the question of people minorities as related to national language. In 2009, Piedmont region passed a piece of legislation in order to grant to the so intended Piemontese language the same protection given to other minority languages by the national statute law 10 years before, 1999. As we already pointed out, 6 of the Italian Constitution states a specific protection for minority languages as one of the fundamental principles of the Italian constitutional order. The Italian court declared void this regional law of 2009 by observing that only the Italian parliament has the power to identify a national community and a minority group within it. A regional statute law cannot qualify as such its own community as a linguistic minority, because citizens of each region cannot be considered as a fraction of the Italian people separated from it. This decision was taken in 2010 by the Italian Constitutional Court. So as an autonomic entity, each region has its legislature, executive, and electoral arrangements within the framework established by the Constitution. Speaking about the legislative framework, according to the amended Article 117 of the Constitution, amended in 2001, 3 different listings of subject matters are provided to share the legislative powers between state law on one side and statute law on the other side. So the first list is about Italians' exclusive legislative competence over enumerated subject matters. I quote just for example, some of them: criminal and civil justice, private law, foreign policy, immigration, market competition, education, customs, national borders, international disease prevention treatments. This is an exclusive competence of the state legislation. It's been very important during the pandemic to rule among the conflicts between regions on one side and state on the other side. And environmental protection, essential levels of rights and services due to the citizens. In a second list of subject matters, the ordinary regions enjoy a legislative competence shared with the state. Subject matters like, also some samples here, healthcare, civil contingencies, land use planning, transport and navigation networks, communications, energy, social security. And the Italian model of shared competencies states that on those subject matters, the central state has legislation limited to the fundamental principles. We speak about framework legislation, while the regions enjoy the competence to define the detailed legislation. And then we speak about residual regional competencies, which belongs to the regions, of course, and it goes on any subject matter not formally enlisted as exclusive competence of state legislation or shared competence between state and the regions. So since the distribution of legislative powers among state and the regions, I mean, for the 5 special regions and the 2 special autonomies of Trento and Bolzano, this listing is the contents of their own statutes approved by a constitutional law, while for the ordinary regions, this listing is in the 117 of the Constitution. I mean, since this distribution of legislative powers is designed by listing different subject matters and not always described with one word, with single words and clear words, after the constitutional reforms of 2001 entered into force, the Constitutional Court had to deal with a huge amount of conflicts of competence, taking hundreds of decisions during more than 20 years. We can easily say that the Italian Constitutional Court gave a substantive contribution to achieving a normalized working of the system. Subject by subject, decision after decision, the real consistency and limits of regional legislative competencies are now designed in an almost stable framework by the Constitutional Court, but never completed framework. The Italian system, although the intentional expansion of regional powers brought by the constitutional amendment of 2001, does not have a political arbitration instrument at a constitutional level. I mean, we do not experience a parliamentary second chamber representing local autonomies like the Senate in several federal states, as our Senate is like the deputies' chamber directly elected by the citizens. That is why the arbitrating role regarding the relationships between central government and regions has been left to the Constitutional Court through the constitutional adjudication on the exercise of the legislative power under the paradigm of Article 117, or the special, the constitutional laws approving the special status of the 5 regions plus 2 special provinces of Trento and Bolzano. And this lack of an institutional mechanism in promoting political coordination and mediation, I mean, among national and regional level of governments, is one of the most relevant defeaters of the Italian regional system. Speaking about unity, it is important to know that the former Article 117 of the Italian Constitution, before the amendment of the 2001, provided for a general limit called the national interest, a kind of supremacy clause protected by state legislation, through which the Constitutional Court was able to declare void many pieces of regional statute laws, pieces of regional legislation, in order to guarantee a stronger territorial uniformity, as well as passed many state pieces of legislation infringing regional competences by the reason of the national interest. This became a doctrine of the Constitutional Court. But this limit of the national interest was then abrogated by the constitutional amendment of 2001. There is actually a kind of second chamber, I already named it, established and amended by ordinary pieces of state legislation, so it's not at a constitutional level, which eventually became, as a matter of fact, the place for all debating concerning the involvement of decentralized institutional interest in many states' political decisions. It can be described as a form of multi-level governance issue, tool, I would say, called the State Regions Conference, which has been able to disarm by discussion and mediation many political conundrums. In the State Regions Conference, the national government, the state government, and the presidents of any of the regions. That is why I would say all the regions decided to give themselves a presidential form of government, to have a stronger president as a member of the State Regions Conference, dealing with the conflicts we facing the state government. So building conventional rules, this conference has been useful to reach a political solution between state and regional level governments in order to avoid to move an action before the Constitutional Court as an alternative. A kind of forum where national policies involving regional issues can be managed and sorted by consensus. But this, in originally conventional solution, has soon been transformed in a binding regulation by the Constitutional Court itself, since an important and famous decision, this decision of 2003, the number 303. So the Constitutional Court brought up almost at a constitutional amendment, because the State Region Conference is not named in the Constitution. So the court held that the principle of subsidiarity stated in Article 118 to rule for a more flexible interpretation of the distribution of administrative powers among national and regional institutions shall be interpreted first as a fundamental tool also at legislative level. This is an important transformation brought by the Constitutional Court doctrine. The subsidiarity is not only a tool for the administrative distribution of competencies, but also for the legislative distribution of powers. And second, it has to be taken, this subsidiarity principle, as a procedural mechanism, implying the legal obligation for state government to reach an agreement within the State Region Conference on any specific issue that also involves regional interests. So where the national government were unable to do so, or even worse, avoided to convene the conference, the state statute law could be challenged for void before the Constitutional Court. And all this is due to the Constitutional Court doctrine founded by this decision of 2003. Another way to serve the appeal for unity acted by the Constitutional Court is to interpret the rules and list of subject matters set in Article 117 of legislative competencies as to say cross-cutting clauses. I mean, speaking about some of the state jurisdictions as cross-cutting clauses through all this national territory. This gives the opportunity to qualify some of the state legislative competences as able to justify, by the need for unitary regulation, their application throughout the national territory, no matter if this could bring to any impact on regional legislative competences. This occurred many times in the Constitutional Court case law, especially by the use of two principal subject matters: environmental protection and essential levels of rights and services. And this doctrine started quite soon after the constitutional amendment of 2001, with the decisions 282 and 407 of the year 2002, just 1 year later than the constitutional amendment. In spite of the rigidity of the list of exclusive and shared powers, the constitutional case law was able in this way to design a new framework in the field of constitutional distribution of legislative competencies. And the impact of the 2001 constitutional reform was also very important for the so-called financial constitution, where the amended Article 119 provided for a significant devolution of powers and financial resources to regional and local autonomies, speaking of municipalities in this case. Even before the financial crisis started in 2008, nevertheless, these new constitutional provisions lacked of an adequate implementation through national legislation. And after the crisis, and also because of the binding constraint of national finances implemented by the European Monetary Union, both regional budgets and autonomy have been deeply impacted, resulting in a counterwave of recentralization. As many other European countries, Italy has approved a set of laws and regulations to implement a new financial reform, putting at stake the need for state requirements, no matter if affecting the autonomic institutional system. So linear cuts in local budgets and reallocation of legislative competencies were approved, which of course had an important consequence in the domain of the capacity of regional government to deal with their political issues. And finally, a constitutional law in 2012 amended many articles of the Constitution, I mean 4 important articles of the Constitution, due to the implementation of the European Fiscal Compact, introducing the so-called balanced budget rule. The new Article 81 on the national, on the state budget, states now the principles of balanced budget and sustainable debt for the national budget and for the budget of all the public administration. It means also regions, provinces, municipalities, and so on. The constitutional law was the number 1 of 2012, brought some changes also to the Article 117 of the Constitution on the distribution of legislative powers. The subject matters labeled harmonization of public accounts and coordination of public finance and taxation system, once listed together under the shared competence between state and regions, have been divided into different competencies, and now the harmonization of public accounts has been listed as a subject matter belonging to the exclusive competence of the state legislator insofar. Substantial modifications were also brought to Article 119 of the fiscal federalism, further limiting the financial autonomy of local governments. And as a matter of fact, the implementation of the so-called fiscal federalism provided for by the constitutional amendments of 2001 fell out of the political agenda and is still standing by. So let's try to go back to the question of unity. I already pointed out that the former Article 117 of the Constitution once contained a national interest clause that was often used by the national government to justify state legislation on subject matters supposedly assigned to regions, while calling for unified and homogeneous discipline crossing all the national territory. But this clause has been cancelled by the constitutional amendment of 2001, as the Constitutional Court were implementing through this supremacy clause, so to say, a doctrine too much compliant with the government centralized view. National government may still use several subsidiary and substitutive powers when calling for unity. In relation to the obligation arising from the European Union and the international legal order, Article 117 states that the regions are responsible for the implementation of international agreements and EU measures subject to the rules set out in state law, rules which regulate also the exercise of subsidiary powers by the state in the case of non-performance by the regions and autonomous provinces. The revised Article 127 of the Constitution, revised in 2001 as well, states that the Italian government may directly challenge a regional statute law before the Constitutional Court within 60 days from its publication. This was also possible before the constitutional amendment, but in that case, government has a previous control on the regional legislation. It was possible to challenge these pieces of legislation before the Constitutional Court, even before their promulgation. Now it's not possible. The state government has to wait until the regional statute law enters into force and can challenge it in front of before the Constitutional Court when it deems that the regional law exceeds regional competencies. In turn, any region may question the constitutional legitimacy of a state or regional, of other regions' laws or measures having the force of law before the Constitutional Court within 60 days, the same rule from its publication, when it deems that said law or measure infringes upon its competence. But the interpretation of this article made by the Constitutional Court, there is no complete equality between the state on one side and the regions on the other side, as the Italian government can allege the violation of any of the constitutional provisions, also not directly related to the constitutional allocation of legislative powers, while the regions may only allege an infringement of their own competencies. But moving back to the substitutive and subsidiary powers, to better understand the constitutional unity mechanisms, we have to say that state government can use against the regions also the measure provided for in Article 120. So here we have two kinds of subsidiary powers. We will see some related to the international obligations and European Union laws obligation on the member states, and the other in case of emergency as security powers to the safety of the national unity. So Article 120 states the regions may not levy import or export or transit duties between regions or adopt measures that in any way obstruct the freedom of movement of persons or goods between regions, so to grant the unity of the national markets. Regions may not limit the right of citizens to work in any part whatsoever of the national territory. There is only one nationality, and this is the state's nationality. The government can act for bodies of the regions, metropolitan cities, provinces, and municipalities if the latter fail to comply with international rules and treaties or EU legislation. And these are the substitutive powers in case of infringement of international and European obligations. But more, in the government can state and acts in substitution of the regional institution in case of heavy danger for public safety and security, or whenever such action is necessary to preserve legal or economic unity, and in particular to guarantee the basic level of supply benefits relating to civil and social entitlements. I mean, civil rights, civil and social rights, regardless of the geographic borders of local authorities. And the law shall lay down the procedures to ensure that substitutive powers are exercised by the state's government in compliance with the principles of subsidiarity and the loyal cooperation. And this piece of legislation was adopted in 2003, is the statute law number 131 of 2003. This piece of legislation provided for a procedural machinery in order to involve the regional organs which did not comply with the European or international duties, giving them a term to do it before the exercise of the substitutive powers by the national government. What has been discussed by the scholars is the entitlement of these powers, because they are exercised by the national government, even where the non-complying regional institution, where the legislative assembly, which also brings to a problem of separation of powers between government and legislative powers. So it has to be said that the substitutive powers enlisted in Article 120 have never been used in practice, as it is for the lack of a second chamber representing the regional institutions as political mediation forum at a constitutional level. The state-regions conflicts are more often challenged before the Constitutional Court than sorted by consensus. So to conclude by considering that, as usual, the judiciary case law is often characterized by opposite non-consequential waves of legitimation of states, stronger decentralization of legislation, or on the opposite, stronger protection of regions' autonomy. As laying on the case law of the Constitutional Court, we are experiencing waves and counter waves of expansion and retraction of regional autonomy by the power of legislative assemblies. And we can assume for granted that, at least by now, to measure the success of the unity mechanisms in the Italian constitutional system is more a question of constitutional court case law interpretation than the outcome of institutional functioning or political action. To say that, yes, we, as usual happens in a time of economic crisis, we are facing what I called an authority migration from the peripheries to the central government, as it also is due to the implementation of the integration process through the European Economic and Monetary Union. So thank you for your attention, and see you soon for the seminar. Thank you.